Hey everybody, welcome to another edition of the Real Estate IQ Show. Today I have a very special guest, Nelson Taracido, an attorney with over 20 years of residential and commercial real estate experience here in South Florida. Nelson, thank you for joining me today.
Thank you for having me, Ricardo.
This is one of the shows that have been most requested, talking about some of the legal aspects of real estate transactions. And we're going to start with a question that is very common amongst our users. What is the closing agent, and what is the role of a closing agent?
Basically, I think the role of the closing agent is a person that gives confidence to the transaction. We have somebody, an intermediary in the middle, whereby the buyer has confidence that they can send the money to a third party. The seller has confidence that they can give documents to a third party. All the conditions of a real estate closing, once they are met, the closing agent then fulfills and finalizes the transaction. And so the buyer knows that their money won't be given to the seller without getting the property. The seller knows that the buyer won't be getting the property without getting their money. And so the closing agent makes sure that all conditions for the real estate closing are met before the transaction is consummated.
Now, in the popular lingo out on the street, people continually talk about the title company, quote unquote. What is actually the closing agent difference to what people call the title company?
Well, title company is a term that is used often. There are states that only do closings with title companies. We're in Florida, and in Florida you can have either a title company do a closing, or you can have a law office do a closing. Basically, that closing agent, whether it be a title company or a law office, sometimes is named a title company, even though perhaps a law firm is doing the closing. And so sometimes it's a misnomer, sometimes it's accurate, but that's what it means.
Now, speaking about title, there is this factor in these closings of title insurance. And a lot of people ask us, what is title insurance? Is it really necessary? And how does that relate to the work of the closing agent?
Right. So basically the way it works in Florida is that the closing, the due diligence in the closing, the work that needs to be done in order to make sure that the property is clean for the buyer is done by the title agent. So many times it's the same as the closing agent, and that closing agent and title agent basically is going to search the public records of all types to make sure that there are no issues with the property. And if there are issues with the property, for the most common example is that there's an existing mortgage on the property, making sure all of those items are satisfied prior to closing so that the buyer receives clean and marketable title at closing.
So part of the closing agent's job in not only coordinating the parties and in ensuring escrow and in doing the due diligence is, for example, having the buyer have confidence that, for example, there's no liens on the properties.
Correct.
Or maybe what happens if the municipality might have put some kind of violation. Do you look into all of those things?
Absolutely. We search all municipal records, we search the public records, and anything registered there will be brought to the attention of the parties during the closing process. And obviously the contract controls what's happening with those items, and we make sure we get those things taken care of.
Let's talk a little bit about the contract, because many of our viewers and clients are from other countries, and this role of the closing agent really does not exist everywhere. The contract here plays a crucial role. Can you tell me a little bit about that role of the contract?
Well, the contract controls everything. You can have a contract say any number of things. We typically have in a residential transaction, we typically have a Florida form transaction, Florida form contract, and in that contract it states what the rights of the parties are in the event something is found, whether it be at the municipal level, whether it's in the public records, and there are certain conditions that have to be met. And for example, if we find something that there's an issue with the title, the contract says that the seller has to take care of those items with diligence and good faith on a timely basis. But in the event, of course, that there's some situations that cannot be resolved, the contract also has language that allows allows the parties to make decisions whether they want to move forward with the transaction with the defect or whether the buyer can cancel because of the defect and receive their deposit back.
And this is one of the main concerns of our clients is what happens to my deposit? Is my deposit protected? Talk to me a little bit about this issue of what the inspection period is in the contract and what that allows the buyers to do, and how does that relate to potential defects in title and how those are covered?
An inspection period, typically in the contract, most of the contracts that we see are the as-is FAR/BAR forms, and in there you're going to have an inspection period that pretty much allows a buyer to cancel for whatever reason at their discretion. And in that time, if the buyer finds any issues with the property or if anything comes up, the buyer can cancel and receive a full refund of their deposit. Even if the inspection period runs out and there's a title defect found on a timely basis, again, the buyer is still protected and can receive their money back if the seller is unable to cure title by closing.
That inspires a lot of confidence. And this as-is Florida form that you speak about is the form used by most realtors in the industry.
That's
correct?
What we're seeing mostly. Like I said, I would say more than 9 times out of 10 are the contracts coming through my office are as-is FAR/BAR forms.
Now, there are multiple key dates in the contract. One of those is the inspection period. There are a couple of other key dates. Could you elaborate what some of those key dates are?
Many contracts have a financing contingency, which is very important. There's also another very popular South Florida time frame is the condo association time frames. There are time frames to get approval by the condo association. Both the financing contingency and the condo process, which are, again, probably the most common things that we're seeing, you're going to have a duty in the buyer to really make sure that they have those timeframes under control and they know what the timeframes are, because there are duties to apply to the mortgage on a timely basis. There are duties to apply to a condo association for approval on a timely basis, and the contract will be contingent and protect the buyer in the event they're unable to get a mortgage or in the event that condo association doesn't approve them as a buyer in the unit. But they're only protected by that contingency if they apply on a timely basis.
One of the key phrases that these contracts speak about is good faith and timeliness.
Yes.
Can you explain to me what would happen, for example, if a buyer puts in a contract but they're leaving on vacation in a week and they'll apply when they get back and the time frames expire? What kinds of situations could buyers face in those circumstances?
In that situation, you have a couple of issues. Number one, that you may not apply on time. So let's say the contract gives you 3 days to apply for a mortgage or 5 days to apply to a mortgage, and you leave on vacation, you don't apply for a mortgage on a timely basis until you come back. And when you come back, you find out that later on, hey, I don't qualify for that mortgage. You may not be protected by that financing contingency, because the seller is going to turn around and look at your time frames and say, well, you applied for the 7 days after the effective date and you had to apply within 3, so you want to get out of the deal as a buyer, but you can't because you didn't apply on time.
Right.
And so your deposit at that point is at risk. So it's very important to apply on time. And not only that, if either the condo association or the lender requires further information from you, whether it be bank statements or questions that they may have, documentation that they require, you also have a duty of good faith to provide those on a timely basis. You can't delay that turnaround time for many, many days without having that contingency be at risk as well.
So these contracts basically provide transparency and a guide for buyers and sellers to really follow and consummate the transaction. And it's very important that our investors, particularly from other countries, understand that this contract is what will guide our actions and should illuminate our behavior throughout the transaction.
Absolutely.
So this is going to be a very special edition because we're going to have a 2-part series. There's a lot to talk about with Nelson. So for now, we will see you in part 2. Thank you.